from Rajendra Prasad Institute of Communication and Management. And we are very excited to have all these speakers with us today and to learn and gain from their experiences and expertise. So I would like to invite Professor Srivastava to um, enlighten us with his speech.
Thank
Thank you so
thank
much.
you so much, Ayushi. Thanks to Preetham, Professor Sophy, for inviting me. It's a pleasure to have Mr. Kareem on board in this session because he has been very closely associated with this whole process of what we call labor reform, but what we should simply call labor law changes. Maybe even calling it labor law reform is probably not the correct nomenclature. So. I have been asked to focus on the whole question of the political economy of reform of labor law, and what does it mean? I mean, what does it mean for workers? What can one do? I mean, the last question which has been put to me is what can one do in a context? What can be done in a context where changes of this kind have happened? Let me begin by saying that. The condition of work or condition under which we work is absolutely fundamental. It's not only fundamental to an economy. The fact that an economy works on labor, works on people work in order to produce, and then that is indeed the economy. But it's also fundamental to the fact that through work we actualize our own creative urges and aspirations. For human beings, work is just not doing something in order to earn something, but it is also a creative expression of our being, which is why we work. It's a pleasure for me, for example, to be with you today, and it's not because of any other thing. So work is really creative, essentially creative in nature. But work also involves, because not in order to work, most people have to earn a living, and then very often work therefore involves a relationship with an employer, and in settings where employers would like to give away as little as possible to workers. Uh, there is not enough time to go back into the history of labor reforms and labor law, labor regulation, and I know that you have many more sessions of this kind planned in this cell. But just to broadly point out that the early conditions under which capitalism and industrialization took place in the world, some of you may have read, maybe it's too now, the age of internet has taken over and people don't read too many novels. But when I was young, novels written by Charles Dickens were very popular when I was in school, and they actually gave you a very visual depiction of what early Britain looked like when industrial revolution was happening, when modern capitalism was beginning to happen. And really, the rise of industrial capitalism correlated with horrendous conditions of labor and work, and everything that we currently talk about or abhor, child labor, long hours of labor, being paid very little, and so on, working under conditions which were very, very unsafe for their health, and everything persisted under those in Britain as industrial capitalism arose. The state had to step in at some stage. Now, it could have been the enlightened interests of the capitalists, to say, well, we need to treat our workers better, pay them better, because after all, workers are going to produce for us, they will work for us. It could have been the enlightened self-interest or collective self-interest, which could have led to a situation like that. But what we have found is that when capital competes among itself to produce goods which are competing on the market, this self enlightenment doesn't work. The collective self entitlement doesn't work among capital as a class. So it is the state which has to step in to regulate the conditions of work in an economy. So the British state stepped in. Gradually, states across the world stepped in to regulate the conditions of work. We had labor regulations of some kind or another. The International Labour Organization became one of the first multilateral global organizations which came on the scene exactly 101 years ago. And that, again, took on itself on regulating the conditions of work through multilateral discussions amongst employers, the state, and workers. So, this realization that capital and labor alone will not be able to create a world which is in a sense which creates conditions of work in which the economy can reproduce itself and grow is a very old realization, and it's a realization. It is a realization which led to the state stepping in and regulating labor and the conditions of work. So labor regulation became a part and parcel of that process. But once again, the state can be seen by many of us as a kind of a neutral empire. But what history teaches us that the state is not really, even in the best of times, the state is not really always a neutral empire. The state seems to act on behalf more of the powerful interests in society. And it goes without saying that powerful interests in society, that capital and capitalists tend to be far more powerful and represent far more powerful interests in society than the interests of workers. And it is in that setting that it often becomes very difficult for state to act as a neutral umpire, so to say. The conditions under which, however, labor regulation took place globally in the early part of the 20th century, and also the third quarter of the 20th century, between 1950 and let us say about 1978, 1980, however, was such that labor was able to make advances, was actually advance its rights and also able to protect its right. Why did this happen? This happened for two reasons. One is that because of the rising tide of working class movements in the West, and because of the pressure that global capitalism felt from competing states in the competing communist states. Uh, Capitalism resorted to what is often known as welfare state capitalism. So countries in the West, Britain, Germany, and so on, they became state welfare capitalists, and they took on a garb in which they also began to look very closely at what would be in the interest of protecting workers' rights and workers' interests. This was one thing. Secondly, another very interesting thing happened in the early part of the 20th century, which was the world was overtaken by the most severe depression that we have seen. Right now, we are undergoing the pandemic, which I am told might parallel the Great Depression of the 1930s in its intensity and severity. But the depression of the 1920s, late 1920s and 1930s brought home to economists like myself and the late Professor Keynes, who also taught at Cambridge, where I did my PhD, was the leading economist at that time. But there were many others who thought similarly across the globe. And the awareness rose that the only way you could deal with a depression of that kind was the state to move in and to generate demand. And in order to generate demand, you have to treat workers well. You could only generate demand by making the workers the situation better so that they could earn and spend more, because and that was one of the major routes by which economies could come out of recession. So, in a particular sense, the welfare of workers became synonymous with the interests of the capitalists because that was a way out of the crisis. And in the post war scenario in Europe from the 1950s and till the late 1970s was dominated by this worldview, which we call Keynesianism. So these two phenomena, one was in the economic realm, the phenomena of Keynesianism, and in the political realm, the rise of the competition which capitalist countries face from socialist countries, and then therefore they need to demonstrate. And the third, as I pointed out, the power of the working class, the organization of the working class. These three led to major changes in the world of regulation, and the ILO led these changes. At the global level, the ILO led these changes. Things, however, began to change in the late 1970s and 1980s when Keynesianism retreated. And I'm not going to say how and why Keynesianism retreated. That's another story for another day. But along with the retreat of Keynesianism, many other things happened. One was in the 1980s, the collapse of the Soviet Union and the countries around it. Therefore, you move from a multipolar world to a unipolar world. The retreat of Keynesianism also meant a global rise of what came to be known as the Washington Consensus, and then what is known as the rise of neoliberalism. So, what is neoliberalism? Neoliberalism is represented by the retreat of the state from the manifest intervention in the economy. Actually, this is only again a garb. It is not that the state does not intervene on behalf of capital or on behalf of other interests in the economy, but it gives a certain precedence to the functioning of the market mechanism. So, from the late 1980s, 1990s onwards, we came into this era of what is known as neoliberalism and the era of globalization. The era of globalization and neoliberalism meant that global capital and the functioning of global capital became very important. This was accompanied by technological changes, and these technological changes led to outsourcing of production to emerging economies like Vietnam, like China, like Taiwan, Thailand, and so on. And these countries then became fiercely competitive among themselves, leading to conditions which are often known as race to the bottom, basically treating labor in a way that basically leading to conditions under which the cost of labor could be cheapened as much as possible in order for them to be globally competitive. So this is the world that India inherited in the 1980s and 1990s. And then we moved into a period where orthodox economists, mainstream orthodox economists of a neoliberal persuasion, began to argue that in India, labor law changes needed to change and needed to reflect the changing reality of the world. They needed to promote much greater degree of flexibility, particularly flexibility in labor hiring and firing. So this is just leads me quickly on to the second part of my presentation, and I have another 7-8 minutes. I'll try to finish within that. So so basically, this has been, if you some of you may be aware of it, since the early 90s, since liberalization took place, there has been a major focus in this country among orthodox economists, what we call also the pink press, the business press in this country, on labor law changes. Now, in India, yes, we did have a peculiar condition. The peculiar condition was multiplicity of labor laws, and there was an urgent need for simplification, rationalization, and harmonization of labor laws. And this was something on which actually there was a great deal of consensus. There was a consensus among trade unions, employers, and the state that this need to happen. For some reason, there was not sufficient movement in the direction of rationalization, simplification, and so on. The government of India set up the Second National Labour Commission in the early 2000s. It was very motivated by the desire to promote labor law changes and in order to make them consistent with liberalization. Uh, and it gave a number of recommendations. The recommendations, the reports of the Second Labour Commission, in fact, are very worthy of reading material. But the recommendations did not elicit the kind of consensus they should, and particularly with the trade unions. One of the major recommendations was to merge the central laws into 4 broad codes and to have a separate law for the unorganized sector. There was also yet another proposal, which was to have a law for the small enterprises. So essentially 6 clusters of laws in the central domain, 4 laws encompassing the 4 broad aspects of labor relations, a 5th law encompassing the unorganized sector, and a 6th law encompassing small enterprises. And there was a debate on what should be the threshold of small enterprises in India. Uh, in the early, as this, after this NDA government came into existence, and I will say a little more maybe in discussion on how this NDA government was different from earlier governments and why it was able to take decisions which earlier governments were not able to take. It launched on this dimension of codification of the laws, the major laws, into four main clusters and four labor codes. So this exercise started in 2015. It underwent, it has a long history of 5 years. Uh, it culminated, this long history, however, was not a history of which this country will ever be very proud of, simply because labor law changes should be carried out in a true spirit of tripartism. And in this whole process, the tripartite discussions did not happen in the way they should have happened. Most of the discussions were boycotted by trade unions and by most of the central trade unions. In fact, for the last 5 years, the tripartite forums of the government, labor, and employers have not met in this country, which is really unfortunate. And then finally, as you know, the laws were passed in Parliament without a single minute of discussion. And this is tragic, given that these laws came after the pandemic, when we saw the worst possible the conditions under which labor works, and its uh, and its you know its precariousness. We saw literally more than 4 crore workers and their families out on the streets of this country, walking thousands of kilometers, exposing the precariousness of labor. It was in this background that these labor codes were brought, and they did not address the problem of precarity, which was thrown up by what happened between March and June in this country. What and here I will just point to 4 or 5 minutes, because you will have a long series on some of these issues. I'll point to just maybe 4 or 5 major dimensions on what I believe these floor clusters did or what they did not do. They started out on a very bad. There were all kinds of definitional problems, inconsistencies, and so on and so forth. But the final codes are more consistent than where they started out. So they have attempted a broad clustering of the laws, a broad rationalization, a broad simplification, and an amalgamation. This is something that has been done, in the final spirit of codification. The manner in which has been done, I have already said, and it's not a manner of which we can be very proud in this country. Now, having done that, what did the code achieve? If you look at the codes, the first code, the code on wages, is a code which it addresses all workers who work for on wages. So whether they work on wages in the unorganized sector or the organized sector, these workers in this country constitute about 60% of all workers. 40% are self-employed, 60% are wage workers. So all wage workers, are concerned with the way wages are determined, the way wages are paid, and so on. The first code on wages theoretically address 60% of these workers. Uh, how we did it and the deficiencies in the code, I will not go into at present. And again, you have an independent discussion on this issue. The other three major codes ended up being focused essentially on what is the organized sector of the economy. So the code on occupational safety and health and working conditions it was did essentially address establishments employing 10 or more workers, or more workers. The code, the industrial relations, again mainly applies to organized sector establishments. The social security code had, in principle, it provided a framework for all workers, but in practice, it only touched upon organized sector. It provided only on organized sector social security laws, did not have anything to offer to any other group of workers. So it remained, how many workers are there above this threshold level of 10 in this country? About 18%. So in effect, the code addressed labor law changes through the prism of these 18% of workers who work in establishments with 10 or more workers. That's the first thing to be noted. Secondly, something ran like a thread through all these codes, which is a greater freedom for enterprises to operate with less restrictions, less regulation, and with greater ease of hiring and firing. And you see this most of all in the occupational code, in the code on occupational safety and health, where you find that the threshold limit of factories has been doubled, where the threshold limit on contract labor has been doubled, the threshold limit of interstate migrant workers has been doubled. So across the board, you find greater freedom to enterprises, a reduction in the level of regulation, and so on. Uh, Third, you find across the board an introduction of a category of worker called the fixed term worker. Now, the fixed term worker is a worker who can be appointed for, as the term connotes, fixed term. Now, this is a category which is expected to stand just above the contract worker. In principle, the contract workers' wages are also should be on par with permanent workers. And so that on that there is no difference between fixed term workers and contract workers. But the fixed term worker will also be entitled to leave and gratuity on a pro rata basis. So he stands somewhere between, she or he stands somewhere above the category of a contract worker. Whether they will in practice be able to get anything better than a contract worker is something we'll have to wait and see. So this is the third important change which was introduced. The fourth important change which these laws introduced was through the Industrial Relations Code, a weakening in the bargaining power of labor. And this was done through in multiple ways, chiefly and I'll only summarize one principal way, which is actually the right to strike, which is a fundamental bargaining weapon in the arsenal of workers. Virtually, a legal strike has virtually become impossible under the IR Act. And I would, I'm sure that Mr. Kareem will be able to respond more meaningful on this, but in my view, that has become a virtual impossibility. So it shifted the bargaining power very, very firmly towards capital. Fifthly, it gives much more leeway to the central and state government to grant exemptions. So the power to grant exemptions are under different parts of the code has been very substantially increased, and the power of the central government in particular to control the state of affairs through the constitution of boards, through the management of finances, and so on, has been significantly enhanced through the codes. So this is again a very, very important feature of what the courts have done. So these are I'll only stop with these five broad features. So what do these five features together mean? Together, what they have done is that they've shifted the balance in favor of capital, and the state has become a much more visible party in labor capital relations than it was there in the past. Now, I just want to very quickly come to the final. I'll take one more minute to point out that this was done. There is a long standing argument among mainstream economists that the changes of this kind are needed in order to increase the quantity of employment in the economy, the quality of employment in the economy, and to improve growth and productivity. But economists like myself and Aditya Bhattacharya and Dr. Shyam Sundar, Dr. Alak Narayan Sharma, and a whole galaxy, Professor T.S. Papola, who is no longer with us, and many, many others have extensively researched on this subject over a number of years and decades, and have shown that these arguments are not based on proper empirical facts, and that while sound labor regulation is needed, and as I said, simplification, rationalization were needed, this is only one small factor in bringing about growth, in bringing about increase in productivity, in bringing increase in employment. And the final point that I want to make is that all labor regulation is made within a broad framework. In the current scenario, the broad framework that we have in development is to promote what is known as SDGs. Globally, SDGs is our goal. And of course, within the country, the constitution gives us certain objectives. Now, this is something, and what are these objectives? Essentially, sustainable growth, growth with equity, and providing decent work. These are the broad, rubrics of goals that we are available to us. And in my view, the labor law changes that have been proposed by the courts are not consistent with inclusive growth, not consistent with equitable growth, and so on. And in terms of what we can do in order to change this, of course, analysis at our level, analysis, understanding the implication of labor codes, bringing it to the widest audience possible through our writings, through our speeches, through seminars is essential. Ultimately, it is the working people of this country who can actually help to reshape labor law changes in a manner in which it becomes consistent with inclusive development and growth with equity. Thanks a lot. I'll stop here, Professor. Thanks a lot.
Uh, Thank you. Thank you so much, sir, for your insightful comments. We've already received a few questions, but we'll take comments from Mr. Kareem and Professor Sophy, and then we'll have a round of question and answer session. I would like to hand it over to Mr. Kareem, but I would also like to read the question which we have for him, for our guests. What is the role and the impact of the political processes in shaping the history of labor reforms in India? Given the significance of labor legislations on the socio-political rights of every citizen, how do you envisage the importance of a consultative and a transparent process in labor lawmaking, and how do we realize it in today's context? Uh, uh, if I may request Mr. Kareem to provide his comments. Thank you.
Thank you. First of all, I thank the organizers for inviting me to this webinar, discussion on labor law reforms and history of Indian labor laws. I fully agree with the formulations of Professor Ravi Srivastava. For the last 2.5 decades, labor law reforms have been passing through turbulent times. Here, one thing I like to emphasize. The word reforms, the meaning has changed. Earlier, the reforms means land reforms was land distributed to landless cultivators or farmers. Reforms in the education sector, earlier meaning was universalizing the education. Now, the reforms in the education sector means privatization of the education. Land reforms means privatization and a concentration of land in the hands of a few. Such a change has come in the world. Historically, labor laws were initiated by the British government in India to satisfy the international community after the birth of ILO. That was mentioned here. Thereafter, many important labor law initiatives were made by none other than Dr. Babasaheb Ambedkar, being the first labor member of the British Council of India in 1942. In the Viceroy's Council, he was the member. He was not only the architect of Indian Constitution, he may be called as the architect of labor laws of India earlier. It was Ambedkar who brought in 8-hour work day to India, bringing in the session of Indian Labour Conference, ILC, in New Delhi, which was held on November 27, 1942. As Labour member of Viceroy's Council, Minimum Wage Act, Prosperity Benefit Act, Women Labour Welfare Fund Act, restoration of ban on employment of women on underground work in coal mines, so and so legislations. Ambedkar set up the Tripartite Labour Council in 1942, that is National Labour Conference, which was later confined to the name of Indian Labour Conference, ILC. It was holding its session in every year. But after the new regime, after 2014, till this day, only one session of ILC was held. On 8th November 1943, Ambedkar introduced the Indian Trade Union Amendment Bill for compulsory recognition of trade while making India's constitution. Labor commissioner and state labor commissioners were first appointed during his tenure. He has also contributed to the making of Provident Fund Act, Factories Act, amendments in Factories Act, and Industrial Disputes Act. After independence, there were such well-known initiatives to labor laws, giving thrust to simplification and codification of the plethora of labor laws. 15th Indian Labour Conference of 1957 is marked in the annals of history for its contribution for the scientific calculation of minimum wages. First National Commission on Labour, headed by Justice Gajendra Gadkar, and Second Labour Commission, headed by Ravindra Verma, reviewed our labour laws and made valuable recommendations. And after that, renowned judgments from Supreme Court also added to reshape the interpretation of labor laws, like that Raptakos bread case, that is regarding the minimum wages. Justice V.R. Krishnayya's decision on Bangalore water supply case, a single labor code was drafted under the leadership of veteran trade union leader Sri Ramanujam in 1990s. That is the short history of our labor laws. Now what happens is already the reverse process of the converting decent jobs and quality jobs to indecent jobs and jobs without quality is going on a large scale in India. Contractualization of permanent jobs, exploitative outsourcing, home-based work, and supply chain operated by big industrials, including multinational corporations. Mass-scale retrenchments and closures are examples that lead jobs in organized sector being shifted to informal jobs. Hence, trade unions are very cautious regarding the new initiative for the reforms of in the existing labor laws. Now, the recently Government of India initiated to codify existing labor laws, and thus 29 existing labor laws are consolidated to 4 labor codes. Earlier, Professor Ravi Srivastava told very correctly, the 3 codes which was introduced in the last session of the parliament and passed it without any discussion. It was intentionally done like that. And those bills were referred to Parliament Standing Committee on Labour. I am the member of that standing committee. We have made elaborated discussion with all stakeholders and gathered all their opinions and made a proper report. Over and above that unanimous report, members like me and some other members submitted some dissent notes also. We submitted in that reports in the 3-4 months ago. But the major recommendations made by the Labour Standing Committee was not accepted by the government. But I was astonished by hearing the Labour Minister's speech outside the Parliament. We were outside the Parliament while he was introducing the bill. He was saying in the Parliament that 75% of the recommendation of Labour Standing Committee is accepted. It was a big lie. Major recommendations, main recommendations were not accepted. Their labor law reforms give statutory recognition to hire and fire, increasing threshold limits in one of the most contentious issues come under this. If an industry with more than 100 workers wants closure, retrenchment, or layoff, it was needed prior permission of the government as per the Chapter 5B of earlier Industrial Disputes Act. Now the code has raised the threshold to 300 workers. What happens? Only a few industries in India will need government permission for closure. Now, after the technological revolution, utilizing the new technology with a few workers, huge production can be done. In such a situation, the number of workers are getting reduced in industrial establishments, and different parts of the work are doing by outsourcing, engaging contract workers and casual workers and daily wage workers. That is a system now. So in the register of a company or industrial establishment, there may be a little number of workers coming under the threshold of 300. So the vast number of industries are out of this law. Fixed term employment, contract employment, union-free workplace, lawless workplace also facilitate the hire and fire. That will be the result of this law. Another important point, withdrawing the inspector, labor inspector, and replacing it with inspector cum facilitator. To whom he has to facilitate? The worker or the industrialist or the capitalist? The intention is very clear. Earlier Prime Minister in a speech openly told, we will try to bring an end to the inspection Raj. That is what is happened through this law. The so-called inspection Raj is removed. Employers are now free to violate all laws and rules without fearing inspector or labor inspection. This is against the ILO's Labor Inspection Convention, 1947, Convention number 81, which is ratified by the Parliament of India. In non-unionized establishments or units with weak unions, surprise inspection is the only remedy. Unless there is a strong inspectorate, economic backwardness will increase in this country. Now, what is happening is this. And unlike any other law, changes in the labor law have to pass through consultation with trade unions as per the mandate of ILO. ILO Convention number 144. This convention has been ratified by Indian Parliament. It is also violated by passing tripartism and trade union consultation in labor-related matters is a part of parent labor reforms. Now it is bypassed. Government think that trade unions are a hindrance to pursuing the anti-worker proposals in the labor and economic reforms. Hence, restricting activities of trade unions is a part of the labor law reforms. Government brought IR code, Industrial Relations Code, containing provision to restrict registration and recognition of trade unions, prohibiting outsiders as trade union office bearers. In a democratic country, existence of more than one trade union is also in the spirit of democracy. Government wanted to legalize restraint on strike and penalize it in a big way in this law. After giving strike notice, if the employer presents a complaint to a conciliation officer, district labor officer or deputy labor officer like that, from that day onwards, no strike shall be conducted till the end of the conciliation. When the conciliation ends, there is no time limit. It can be extended from DLO to Joint Labor Commissioner, State Labor Commissioner. Like that, it may extend to any extent. Process when the process is over, this conciliation process is over, then only workers can strike legally. For each day of illegal strike, what happens? 8 days' wages can be retained arbitrarily by the employer. In India, after this IR code, no legal strike will be done by the worker, by the trade unions. That what may be happen. See, the full impact of the new acts can be assessed only after the draft rules of the legislation are finalized in the coming months. Increasing contract labor, replacing permanent jobs is a burning issue in the organized sector. It means quality of jobs being converted into cheap or low quality jobs with exploitative wages and shabby working conditions. Government encourages contract labor system to make in the default exploitative arrangements. For the purpose, a new provision called fixed term employment also is proposed. That is agreed in the accord to replace the mandatory permanent jobs. There is no limitation for this fixed term employment. In China, there is a condition. After 2 years service, he will be getting permanency. In Korea, there is such conditions. In several countries, because in seasonal industrial establishments, there may be required some seasonal workers that we can understand. In the earlier notification in India, it was defined like that. Now, wherever the management feels it is necessary, any worker they are engaging into a job in the permanent nature, they can make it fixed term employee. What does it mean? Giving the appointment order with the retrenchment order, 2 years, 1.5 years, 1 year, and intermediary, they can terminate them as and when they feel like that. That is the position. The permanent job are vanished from the world of work in India. That is what is happening. Fixed term employment is also proper. The another thing, permanency of employment will be a foregone concept. Already we have a plethora of such temporary categories like apprentice, trainees, casuals, badali, etc. Second Labor Commission has recommended that after 2 years, all jobs should be treated permanent, but it is not accepted. Every labor code contains provisions for the government to arbitrarily exempt it is told like this. Wide discretionary powers conferred to the central and state governments for allowing exemption from the laws will ensure that even the limited gains assured will remain elusive. That may be happen. And another thing, this is against the elusive concept of rule of law. The government is withdrawing from many people-related sectors, including labor sector. It wants to expand the exemption regime in various labor laws. Many laws are excluded from application by raising the threshold limit. I'm not going further. See, earlier, Professor Ravi Srivastava told very correctly, the labor protection and welfare state concept was developed after the Second World War era, when the Soviet Union-led socialist bloc was combating the capitalist world, the bipolar world. The capitalist rulers and class were afraid of working class revolution in European countries. In Britain, Italy, France, Germany, working class movement was very strong and they were challenging the capitalist classes those days. So the rulers, the capitalist rulers, afraid of a working class revolution in those countries. And another thing, the thesis of Maynard Keynes, demand management, and followed by welfare state concept, that also accepted by the ruling class, capitalist class, only because of the existence of Soviet Union and a strong socialist bloc. But after the Second World War, following the Keynesian thesis and the welfare state concept in capitalist world, there were tremendous development. It was the golden age of the capitalism. You see the technological revolution in IT, BT, and electronic sector. There was much advancement, and the wealth created by thus enormous. And after the collapse of Soviet Union in 1991, the neoliberal policies was advocated by Milton Friedman and other capitalist thinkers, denying the thesis and the dictates of the Maynard Keynes, and a new style of capitalist was in power. They advocated for the neoliberal policies and the globalization, utilizing World Bank, IMF, and World Trade Organization. India now following that concept, it led to big serious economic crisis and distress of the people and the present condition of our country. Now these labor laws period in our country, what may happen? They are not recognizing the issues in the demand side. They are only period also. Nothing have been done for the welfare of the poor workers in the unorganized sector and the migrant workers. The number of my interstate migrant workers may come more than 5 crores. Total number of the migrant workers in India may come 15 crores. The total workforce in India is calculated as 56 crores. Among them, 5-6% are working in organized sector who are getting little benefits, a reasonable wage, and other social security measures, ESI, Provident Fund, bonus, like that. The vast majority of Indian workforce are unorganized sector, informal sector, traditional sector, and self-employed. What are they getting? In the minimum wage concept, it is also supported in this law. Minimum wage for certain scheduled employees. Vast majority of this unorganized sector, particularly in construction, in motor transport, and this trade and hotel, like that area, and fishery workmen, scheme workers in that area. A new concept is introduced in the law, that is national floor level wages, that is below minimum wage. What is the national floor level wage? The minister announced that it may be 302 rupees per day. But the expert committee not 300, 202 rupees per day, not 300, 202 rupees per day. An expert committee was appointed by the present government in 2017. That committee recommended the minimum wages should be 380 per day. Their own committee's report is not accepted. So one part they say on minimum wage, other side they say national floor wage. What will happen? The concept of minimum wage was accepted by 15th Labour Conference, and what calories to be were taken, what is the minimum quantity of the calorie, what will be its value. It is scientifically calculated, and the 7th Pay Commission to central government employees calculated the minimum wage should be 21,000 rupees per month, 700 rupees per day. All these concepts are thrown away. Now, the workers can't form a trade union in industrial establishment. They can't go for a strike in an industrial establishment. All strike can be treated as illegal strike. No trade union can be allowed to function. What may happen if this is happening in our country? What will be the living conditions of these poor, unorganized sector workers, crores of working people of our nation? So this is a disaster. So entire trade unions opposing these labor reforms, and we are fighting against it. The coming 26th of November, national strike is announced. With these words, I conclude my speech.
Thank you so much, sir, for your insightful comments. I would like to invite Professor Sophy for her comments, and I would just speak out the question which we framed for her. In light of the fact that labor reforms are usually recommended by commissions through their reports, could you shed light on the manner in which labor reforms are projected in these reports and other policy documents?
Thank you so much, Preetham, for the questions. Uh, Thanks to the Legal Aid Committee for organizing this lecture series on labor reforms. It's very important to start an educative process on how labor law has been transformed to deal with economic challenges of the time. Whether in the process the social justice framework has kept intact by ensuring decent work with dignity for the workers of the country is the important question that we all need to interpolate on. I'm very thankful to both the speakers, Professor Srivastava and Mr. Kareem, who brought forth the economical dimensions of labor reforms in the country so far, and also the political process that kind of dismantled the consultative process that labor law reforms that have followed so far in the country. Both the panelists shed light on different aspects of labor reforms. I thought of looking at certain committee reports that has come so far in the country in order to see how labor welfare and labor reforms have been talked about in the report. It is just to understand whether what we are witnessing today is actually labor reforms or not. I'm sorry, my video is not on. Okay. Hope I'm visible now. Yeah. Okay.
Yes, ma'am.
So it's very important to understand how labor reforms, the terminology labor reforms has been understood in the labor literature, in the labor amongst labor scholars and labor literature. And for that, it is important to look at Sydney and Beatrice Webb's understanding on enunciation on what is labor reforms. Uh, for them, labor reforms intend to raise the condition of the working people, reduce the class conflict, and make the world of work more efficient, equitable, and democratic. So the question is whether the labor reforms today actually raise the conditions of working class people, or whether there is an efficient system that would ensure efficiency of the work at the shop floor. And when Sydney and Beatrice Webb put forth this idea of labor reforms, they also thought about two-pronged labor policy program to promote this social and economic efficiency. The first prong is to improve wages, conditions, and treatment for workers in the lower part of the industrial pyramid. Doing so also keeps wages growing in line with productivity growth, thus maintaining macroeconomic demand, supply balance, and social justice. So it was basically wage-led growth that they talked about while talking about improving wages for working class. American writers call this raising the plane of competition. To accomplish this goal, the Webb's proposed establishment of a common rule that extends across the national labor market and required all employers to provide a minimum standard of terms and conditions of work. This is very important because when we look at the history of labor law in the country, at every juncture of time, uh, there was intervention from the part of the trade unions, labor activism, uh, to change law in order to suit the demands of the workers. And we see that Industry Dispute Act, which was enacted in 1947, contained very limited provisions in the original draft. But later it was because of the very vibrant labor union activism that we have Industry Dispute Act as we see today. We see Chapter 5A, Chapter 5B, and 5C were inserted into Industry Dispute Act much later, and they remain as strong parts of Industry Dispute Act today. However, when we look back, the policy documents relating to labor welfare or labor reform, the first document that comes into picture is the Royal Commission on Labor Report 1929, which is actually submitted on 17th January 1931. The Royal Commission on Labor was appointed to look into conditions of workers in industrial undertakings and plantations in British India. The recommendations in the report were reformatory in character and aimed at labor welfare. I say this because I say this based on the recommendation that is postulated. Some of the recommendations uh, were the following. The first important one is about the rationalization measures that the employer should contemplate on. So it's sort of recommended for availability of a joint unemployment insurance before the rationalization takes place in an industry establishment or factory. So it basically says because of rationalization, there shouldn't be any complete deprivation of livelihood. There has to be minimum assurance about access to minimum compensation. And then we see that the Royal Commission on Labor talking about reduction in working hours. So it says states should ensure that the working hours shouldn't go beyond 50 hours in factories. So this report is of 1931. So we have to contextually understand the recommendations as well. These recommendations needs to be also compared against the current labor reforms today. Maybe in the later sessions we can do this, how reduction working hours or the regulation relating to or law relating to working hours are dealt with under the current labor reforms code. One of the other recommendations in the Royal Commissions on Labor was about intervention of local government. So it stated that local governments should have the control in determining the shifts in working hours. It should inspect, in the sense that a government should ensure that inspectors have adequate powers to inspect the factories and ensure safety, and also welfare provisions like separate latrines for male and female workers, creches, canteens, etc. for workers in the factory. So when we look at this Royal Commission on Labor, there are enormous provisions which sort of indicated labor reforms for the workers then. There were elaborate provisions on how plantations labor should be dealt with, and wage settings should be done in the plantations. Maternity benefits should be provided to them, etc. The report also emphasizes that generous and justiciable policy for labor increases the prosperity of the industry in India. So in a way, it states that it's so important to ensure redistribution to the laborers for the prosperity of the industry in the country. So industrial activity can be strengthened only by redistributing economic benefits to the labor. It is with this mindset that the uh, recommendations were given by the Royal Commission on Labor. So when we look at the first Royal Commission on Labor, it was looking at labor welfare, industrial establishments, and plantations. It sort of gave a lot of provisions, recommendations for increasing the welfare in industry undertaking. The second document that comes to the picture is the first National Labor Commission report of 1969. The speakers have already mentioned about this report. As it was mentioned, the chairman of the commission was Justice Gajendra Gadkar, one of the scholar judges who contributed to social justice framework uh, to labor jurisprudence in India. It stated that the aim of the commission is to make recommendations that would adhere to Article 23 and 43 of the Constitution. As we all know, Article 43 of the Constitution guarantees to every citizen the right to work and right to work and working conditions consistent with the dignity of human citizenship, conditions which would enable the worker to enjoy in full measure his democratic right to participate in life, liberty, and happiness. That directive principle naturally has inspired the development of industrial laws since 1950. It was during this, it was post 1950, we see that industrial law has developed in various ways. And we have also seen that judiciary and tribunals, industrial tribunals have contributed to uh, growth and strengthening of labor jurisprudence in the country. The commission, the first National Commission on Labor, relied on the principle that for industry harmony in a democratic country, there has to be a policy that ensure fairness to the fair redistribution to the employee, and this fair redistribution to the workers should be consistent with the good of the community. It is with this predicament that certain recommendations were given by the commission. And I don't get into the details of the recommendations, but we can see that certain recommendations were around layoff retrenchment compensation, how it should be ensured to workmen. So there was emphasis on the principle of rationalization without tears. This actually is a follow-up initiation from the recommendations of the Royal Commission on Labor. And there was also a recommendation that there should be further reduction of hours of work to 40 hours. So this standardization of working hours, standardization of holidays, these were consistent recommendations from Royal Commission on Labor onward. And there was also a recommendation that contract laborers should be entitled to use all welfare facilities which are meant for direct workers under the existing legislation. So in a way, the contract workers should also get amenities that are available for direct workers. And another important recommendation that we see in first National Commission on Labor report is the measures relating to automation. So it stated that before automation is brought in an industry establishment, it should make sure that the surplus labor is provided with alternate employment. So and it also stated that compensation should be ensured to workmen based on their continuity in service. So there were a lot of, again, reformatory measures, welfare measures in the first National Commission Labor Report. There was even provisions relating to land and housing rights of the workers. However, we see that there was mention of Common Labor Code in the first National Commission on Labor Report itself. I quote from the report. It says, considering the variety of subjects presently covered under the labor legislation, it will not be practicable to formulate a common labor code having uniform definitions all through and applying to all categories of labor without any distinction. Since labor will continue in the concurrent list, adjustment to suit local conditions in different states will have to be allowed. These adjustments in some cases may not necessarily conform to the letter of a common code. In order to bring about a feasible degree of simplification and uniformity in definition, it should be possible to integrate those enactments which cover subjects having a common objective. This will mean a simplification of the existing framework of labor laws. I unquote here. So from the words of the first NCL, first National Commission on Labour, it's evident that it recommended for simplification of the existing framework of labor laws dealing with subjects having a common objective. But it emphasized on maintaining distinctions within labor and regional variations of labor and to ensure decent working and living conditions of diverse occupations. Though it recommended for simplification, it emphasized on keeping the labor distinctly within the legislations itself and addressing the different variations in demands coming from different sectors of employment. One of the criticism against first National Commission on Labour was it failed to look at the huge chunk of workforce in the unorganized sector and initiate policy for that. Post 1969 report, we see that there were many changes that took place in the Industry Dispute Act 1947, and also we see changes in Trade Union Act as well. We also see that there were several welfare legislations like social welfare legislations like Bond Labor Act, Contract Labor Act, all of that coming in during that phase. The next policy document that becomes important in the labor reforms context is Second National Commission on Labour Report 2002. When we look at this report, two important tasks that was assigned to Second National Commission on Labour was one was to suggest rationalization of existing laws relating to labor in the organized sector, and the other was to suggest an umbrella legislation for ensuring a minimum level of protection to the workers in the unorganized sector. It clearly stated that rationalization means only making laws more consistent with the context, more consistent with each other, less cumbersome, simpler, and more transparent. So rationalization only meant simplification of the procedure within the enactment. It never meant explicitly to go ahead for dilution of the labor rights as it existed in the as it exists. And it also sort of suggested for certain protection and welfare measures. It in a way asked the government to enact certain welfare provisions for debilitating disease, accidents, or old age. And it also suggested for simplification of labor laws into 5 codes, as it was mentioned by Professor Srivastava. And then there was also a provision that no contract worker should be kept as a contract worker for more than 2 years. There was a provision which recommended for, there was a recommendation for payment of bonus. All of these very important welfare provisions were there in the Second National Commission on Labour report as well. However, we see that this was one commission report which was highly criticized by the trade unions and labor movement then, mainly for the reason that this was more oriented towards bringing changes in labor laws that make the labor flexible. So the whole approach of the commission was not to really empower the workers or bringing reforms to increase the welfare of the workers or to equate the or place the worker in equal pedestal with the employer. It was all about how to shed the rigidities and within the labor law as it was instructed by the Washington Consensus. So this is later, in the sense, even Second National Commission on Labor, they did not even talk about Social Security as a matter of entitlement. This was even reflected later in the Unorganized Sector Social Security Act. The Unorganized Sector Social Security Act doesn't really doesn't contain Social Security as a matter of right. It just compares certain schemes available for BPL families under gamut. So another, I think, after Second National Commission on Labor 2002, another report that is worth mentioning is NCUS report, which came out in 2007. It's titled as Conditions of Work and Promotion of Livelihood in the Unorganized Sector. This report was highly pathbreaking in terms of bringing out statistical data relating to unorganized sector. The demography of the unorganized sector was clearly drawn out. The caste-wise uh, composition in the unorganized sector was really brought out, and also that the self-employed category, the data relating to self-employed category was really brought out. So this sort of showed how much of the working population is left out of the mainstream labor law. I think that's where even today, when we think about labor reforms in 2020, we need to really think whether the present labor reforms has brought anything new, or whether it has tried to reconceptualize labor law framework around the nitty-gritties of working population in India today. Today, one of the biggest failures of labor law had been its inability to engage with questions of social identity, including those of caste and gender. Labor law failed to address the question of gender. We have seen that in multiple times, through many cases as well. Shahrukh Rana's case and Air Hostess's case, all of that is there to understand how labor has, especially the mainstream labor, has failed to address the issues relating to gender. And also, when we talk about the exploitation of worker, we need to also think about how to find out possible alternatives to criminalization in dealing with issues of labor exploitation. We have the labor law framework, the concept of labor law framework to address issues relating to exploitation. So that's where I think we need to reconceptualize labor law in today's context. And we also know that feminists have long ago started problematizing the gendered character of labor law for not addressing uh, uh, the rights of women workers engaged in reproduction work. These theorization also don't get recognition in the current labor law framework today. I think something serious that we need to rethink upon. In 2019 periodic labor force survey report also stated that the women's labor force participation rate has come down to 20%, which was 30% in 1990. And the studies around this formulation has also stated that majority of the women who enter workforce today, they all end up entering into unorganized sector. So unorganized sector employment. I think this is also a crucial thing that we need to think upon. So majority of women workers, they're entering into informal sector today, and they end up not getting any protection under the labor law. So it's at this moment I would like to ask certain questions and end my presentation here. The questions are the following. The first question is whether the labor law framework in India uh, uh, address intersectionality discourse that has already evolved around labor law in the Western Hemisphere. So whether we can ensure dignity at work without addressing the elements of caste and gender within the labor law framework. And second question is whether these reforms constitute dilution to the existing labor rights under the legislation, or whether these are actually reforms in the sense that we have understood through earlier commission reports. And the third question is if it is consolidation of the existing legislation. Most of the legislations which got consolidated under the courts today, these are applicable to organized employments. So whether there is a need for separate legislation for the informal unorganized sector. So what are the possible legislative and judicial strategy to strengthen rights-based approach within the courts today? And what should be the strategy forward while we ask for or demand for working around the labor law reforms that have come onto the anvil? I end with these questions and open to interaction in the further conversation. Thank you all.
Thank you so much, ma'am, for your valuable comments. I would like to invite our attendees for question answers. If any of you have any questions, you can raise your hands and I'll unmute you and then you can ask directly.
Um, Good morning, professors, Professor Srivastava, Professor Sophy, and Mr. Kareem. It's an honor to be in conversation with you all. Now, my question is that in today's time of the pandemic, when most of the companies are undergoing severe losses or bankruptcies, how would we justify labor welfare as being synonymous to capitalist welfare when it actually adds to the burden of the corporate, which is actually piling up quite high, and then cost cutting is necessary? So how do we justify labor welfare at a time like this?
Who do you want to answer this question?
So anybody could answer, but Honorable Professor Srivastava, anybody, I mean.
Okay. So I think the concern is a legitimate concern. The concern that, if there is a crisis, then that does crisis entail cutting down of labor costs? And if it entails cutting down of labor costs, does it mean that labor should be, paid less, or should we have a more rights-based and welfare orientation towards labor at this hour? Now, this is certainly a part of a mainstream thinking, which looks not only at individual capital, but which also looks at growth of capitalism in the same framework. And in fact, it is this framework which led the center to propose that states carry out very wide-ranging labor reforms during the pandemic. As you know, many states actually virtually abandoned the labor regulation, including Uttar Pradesh, Gujarat, Himachal, and so on. And by not only, I mean, the whole arena of labor reform, labor regulation was abandoned by them. To some extent, then the ILO stepped in, and the presidential assent was the same. But then now we have the codes in the same spirit coming. So there is what you are enunciating is a general argument. The general argument says that we must give as much freedom as possible to capital in order to downsize labor and to downsize labor costs in periods of crisis. Now, essentially, the argument, we began with this argument. If you remember, I gave you the example of the last depression. I gave you the example of the last depression, which was the more serious than the present pandemic, and maybe equally serious. And the lessons which were drawn during the last Great Depression of the 1920s was that if countries want to get out of that Great Depression, they can only do so by giving labor a better deal, by putting money into the hands of labor. Because when you do that, you create what we call, economists call, a virtuous cycle, there will be more money in the pockets of labor. Labor will be able to spend more. When they spend more, more demand will be created. But more demand will be created, capital will produce more and will produce more profitably. So this whole argument, if you look at it only from a very narrow perspective, then you reach the kind of conclusion you do. But if you look at it in terms of a virtuous cycle of growth, then in fact you reach the same conclusion that economists reached almost 90 years ago, which is that it does not pay capitalists and it does not pay the economists to keep cutting back on labor costs during the crisis. That's one one way of looking at it. The second perspective on the same issue comes from the fact that capital needs to increase productivity of labor, and you cannot increase the productivity of labor by constantly cutting down of labor costs. And by the way, let me also tell you that labor costs are a very small proportion of total costs, total industry costs. There's a total myth about labor costs. Actually, if you look at labor costs, I don't know how many of you do a case study of Maruti and the Maruti strike in as part of the work, I mean, course that you do. In Maruti, labor costs were about 1.8% of the gross cost of production. And Maruti, despite its very low labor costs, had kept a very large part of its labor completely as contract labor. You know, apprentices were working for decades as apprentices without being absorbed in the labor force and so on. If you look at the most labor-intensive industry in this country, for example, if you look at the apparel industry, garment production. In garment production, the cost of labor is only 5 to 12% of total labor cost. Only 5 to 12% of total cost. The rest of it is basically fabric cost and various other costs, electricity cost, cost of infrastructure, cost of rent, and so on and so forth. So the idea that you can actually, capitalists can only survive by lowering labor costs is neither, it neither serves individual capital, nor does it serve the interest of capital as a class and the economy as a economy as a whole. So this idea that you can only cope with a crisis by cutting down the cost of labor is not a correct one. And if indeed at a point of time in the pandemic there is a genuine crisis and capital is not able to pay labor what it should be able to pay labor, then it is for the state to step in and subsidize the cost of wages. The state to
Sir,
step in.
may I add a follow-up question, sir?
Sure, but this is my sum and substance of my answer, that we have a lot of history trying to tell us that this understanding that only by cutting the cost of labor can you cope with the crisis is not the correct understanding. Although there are a lot of mainstream and neoliberal economists who are of the same persuasion as the argument that you pointed out.
I would like to intervene on this question, this particular question. May
thank
I?
you, sir. Yes, thank you, sir. Please,
Yes,
sir.
The question was how the industries during this pandemic period protect the interest of the workers by giving wages or something like that. My answer is governments can intervene in this juncture. What happened in the European countries during this pandemic? Their packages were from 10%, 11% to 21% of the GDP was allocated as a package to industries and for other welfare measures. They requested all the industrialists to pay wages to all workers, and 70% of the wages was provided by the government. What happened in our country? There was a package of 20 lakhs crores of rupees announced by the government. The government share was only 1% of the GDP. The major portion of the package was to be given by the banks. That is not happened.
Less than 1%.
Yes, less 1%. We, the trade unions, demanded let the government give 7,500 rupees per worker or per the poor peasants and workers for 6 months. Where is the money? They can borrow the money from Reserve Bank. Nothing may happen. Instead of that, government says to states, you go to banks and get money from banks. what will be the percentage of the interest, how can a state afford that burden. So the government was washing their hands and escaping from all the liabilities and putting all the problem on the poor people. That was what was happening. The demand side was not taken care of the government. They were only taking care of the supply side. Now you see, during this pandemic period, Mukesh Ambani's wealth was going up. How it happens? So the issue is the political economy, the policy.
So this is Nandini Goel again, and I would like to add up a follow-up question to this. So during this pandemic, it has been a unique situation. The supply side chains have been disrupted, the demand side chains have been disrupted. And in most of the cases, our GDP has been for the first time in a negative. And like you pointed about, government subsidies, government expenditure, uh, uh, India has a very high debt burden on it. So how do you think can we apply in this case? Because in this case, where companies are facing bankruptcy, they are themselves in a very high debt burden. How would we justify all these government spendings and in this time labor welfare? This is my
No,
question.
no, no. I think first of all, your understanding is wrong. India does not have a burden, a debt burden, either internal or
Fiscal
external.
deficit, sir. The high fiscal deficit.
No, the fiscal deficit, high or low, is something again. There's a lot of argument about it, and not only. In fact, this is the first time that even economists within the government, for example, the chief economic advisor, sorry, not the chief economic advisor, but the chairman of the Prime Minister's Economic Advisory Council actually broke ranks and said we need to spend more. Normally they speak with one voice when they are within the government, and almost every well-known Indian economist outside government and globally said that we can and we need to spend more. The fiscal deficit is a variable which governments, sovereign governments, can control. They only get worried because fiscal deficit is something which are used by international credit rating agencies. But if we are able to manage the economy better, then credit rating agencies follow us. So this argument that our fiscal deficit was too high, or that our debt burden was too high, and therefore we could not have spent more, is a completely erroneous argument. The globally, economists don't believe in it. I mean, and I'm not going to name economists who have argued that the Indian economy, Indian government should have spent much more. It is absurd that in the times of pandemic, the total fiscal expenditure outlay that this government made was to the tune of about 0.85% of GDP. I mean, it is really is absurdity. In the 2000, after the 2008 crisis, we spent roughly about 3% of GDP. Additional money outlay made by the government was roughly about 3% of GDP. And this government decided to spend around 0.85% of GDP. If you ask me, this was economically suicidal. And this has prolonged the impact on the economy, on everyone in the economy, the working people in the economy, but also those who are producers, the business class itself, except for a very tiny section of industry, which is of course making gains, as has been pointed out to you. So this argument that fiscal deficit is too high is not an argument which is accepted by overwhelming majority of economists.
May I add one word?
Yes, sir. Please, thank you, sir.
Okay. Regarding this fiscal deficit and fiscal responsibility, I agree with Srivastava. See, that is World Bank's thesis. Fiscal responsibilities act was passed by the parliament during this neoliberal era. For what it is introduced? To reduce the government's role in public expenditure. You don't intervene in infrastructure development, manufacturing, or any other industrial sector. You only do the overall governmental management. That is the advice from the World Bank. All other things can be done by private investments in all sectors, education, health, everywhere. That was the advice from World Bank.
but
Hence, the Fiscal Responsibilities Act was covered. Now, it is not a question of fiscal deficit. Why the government reduced the corporate tax in last year considerably? So the question is the economic policy, wrong policy of the government, as per the advice of the neoliberal agency.
just one more word on this, that it is extraordinary that the most conservative multilateral institution globally, which is the the International Monetary Fund, actually the IMF is on record as saying that India should be spending more during this crisis. Okay. Okay.
Yes.
Sir, but
Yes,
this
yes.
is Nandini Goel once again. Sir, how do you propose that,
All
sir,
well-known
bank,
economists, Raghuram Rajan and Abhijit, several economists have like that.
sir, this is Nandini Goel. Can you hear me?
Yes, please carry on. Yes.
Thank you, sir. Sir, how do you propose that the banks are reluctant in lending to the businesses? So how does the labor benefit trickle down? I mean, when the banks are reluctant to lend to the businesses, and after all, it trickles down from the businesses, jobs are created, and then labor benefits. So in this scenario, how do you when there is low jobs in businesses, how do you how, I mean, in cities, I mean, in this crisis.
So this is why, Nandini, we are repeatedly saying that it is the duty of the sovereign is the state, to actually raise finances and to spend them and to make them available to businesses, either through wage subsidization or through some other means. Because at the moment, businesses can't borrow. The businesses need to repay the debts that they already have. The banks are worried about NPAs because right now NPAs are not being calculated, but 3 months down the line, the counter will start running for them. So both businesses do not want to accumulate additional debts. Banks don't want to lend more because they will accumulate NPAs, and their capital account, their accounts will come under pressure. This is why we cannot have what we call a monetary solution to the problem. This is where the role of the state and the sovereign, what you have seen through the academic, through the whole pandemic, is something extremely distressful. At all critical stages, the central government has stood aside, and it has let it has allowed the pain to accumulate. You saw the migrant crisis. You are all peoples of this constitution. Whose responsibility is interstate migration in the constitution? Is it in the central schedule? Is it in the concurrent? Which schedule is it part of? It's a responsibility of the interstate migration is a responsibility of the central government. And what did the central government do? It stepped aside and it said the state should coordinate the movement of migrant workers. It even said that they should be paying the railways the money to ferry it is only when the opposition and other people raised a voice, then it said, okay, I'm sorry, it initially said migrants should pay for their journeys back. And then the states paid for the trains, not the center. Can you imagine a situation like this? So, the problem here is that the center has been not only cautious, it has been willy-nilly, totally unmindful of the cost of the way policy has been initiated, cost to the poor, cost to the migrants, and cost to the economy.
But banks are, so I agree to your point, but banks are the only medium presently. Is there any other
Banks are
source
commercial entities, Nandini.
Yes, sir, that's
Banks
what
are
I'm saying.
commercial entities. So
Sir,
banks have to worry about the cost of lending. They will not lend just because you ask them to lend. They're worried about the cost of lending. And the cost of lending is related to them about the risks. The risks whether entities to whom they lend, whether they will be able to pay back. In a pandemic, they're already worried about the loans which are there in the system. Whether the entities, the private enterprises, the individual borrowers will be able to pay back to them what they already owe. So it just because the central government tells them that please follow a monetary route doesn't mean that the banks will open their coffers.
My question is,
Thank you so much, sir. Oh, okay.
so, sir,
Professor
so it's
told about the
Yeah.
interstate migrant laborers. One incident I may tell you, the Interstate Migrants Act is subsumed in social that OSH Act. That act has gone.
Yes.
Another thing, in this pandemic period, the economic recession and other issues, we have to study much from China. The only one economy in the world which has shown a positive growth in GDP is China. What is the model of China in broad? Whenever they find any problem in outside market, in export market, they will boost the domestic market by increasing the wages of the workers and huge amount they will spend on infrastructure development and other areas by which the money may reach the hands of the workers and other peoples. In such a way, we can also do. When the government is observing the demand side, they will have to give some money to the hands of poor workers, interstate migrant workers, unorganized sector workers. Then they will purchase the producers. Here, there is no money. Their purchasing capacity has gone. There is no work for the unorganized sector workers, informal workers. They are starving. Literally, that is the position. That attitude should be changed. That policy has to be changed.
Thank you so much,
Thank
sir.
you,
thank you.
Preetham. Just to add to the conversation, Nandini, your argument, this argument was very relevant even in the debates around liberalization in 1990. So one of the arguments that came from Washington Consensus was India should do away with its rigid labor law regime or protective labor law regime to promote more foreign direct investment and promote more foreign multinational companies, establishment of multinational companies in India. So this fiscal deficit, the ground of fiscal deficit was used against Indian labor law regime to flexibilize Indian labor law regime during that time. And as Mr. Karim mentioned, it's so important to increase purchasing capacity of the population, the workforce, in order to start vibrant economic activity in the state. I think that's it's with that realization. I think of late the government has also come up with approving bonus to central government employees, and they stated that it's important to give money in the hands of middle class to push the economic activity. So, but they never give it to the migrant workmen. And we know that even when this crisis happened, a lot of money that was lying in the construction workers board, all of that were not properly redistributed into the hands of the construction workers. So, it's all about how much political will the government has in order to look into the affairs of the labor and what is the vision in the policy, labor policy, in terms of promoting the labor welfare and to intervene in the labor's life positively.
Professor Sophy, just to add to this, and this is this whole argument about, it's very intrinsic to neoliberal thinking. The argument which Nandini has made in another way, this whole question of wages, flexibility of wages, downward. I remember, we in the NCUS, we had proposed the national minimum wage as a legal national minimum wage. And I remember that when we went to meet the prime minister on the then prime minister, not the present prime minister, and we made a presentation of the draft of the conditions of work report, which you talked about, which included this proposal of a national minimum wage. There was a very hostile, negative reaction from the then prime minister, who was himself an economist. And what the argument that he made was very clear. He said, I will never accept this. I will never accept this. Why? Because you will make the labor market rigid by having a national minimum wage. Wages should be allowed to go down as much as possible. So I'm saying that this basic neoliberal doctrine, and we know that all civilized countries in the world took a lot of time, but a majority of countries now have have minimum wages across the board. including
Yeah.
the United States of America, which is one of the most neoliberal economic regimes globally. But it takes a lot of time. It takes a lot of doing for countries to accept some of the things which are against the grain of neoliberalism.
I think in
Um,
2015 there were two important reports that came out. One was World Bank's report, and another one was ILO's report on World Employment Social Outlook. So both the reports stated that austerity measures on the ground of fiscal deficit doesn't really result in employment growth or economic growth. In fact, World Bank report itself stated that lack of collectives and trade unions and lack of redistribution of wages has increased the disparity between the haves and have-nots. So World Bank saying this in 2015 is something that we should
Yes,
also
absolutely.
seriously look into.
Yeah.
And even ILO's report was basically saying austerity measures which cuts the social security of the workers doesn't really help in employment growth. So productivity and vibrant economic activity in the country would depend on how much money, how much redistribution that has happened in the ground level. So it's the lower bottom of the industry pyramid which need to be given, provided with more resources, more financial resources to promote
Absolutely.
the economic activity. Yeah.
uh, Thank you so much, ma'am. We have a question for Professor Srivastava. I'll just read the question out for him. Uh, the capital was it's in the chat box. I'll read it out. The capital was aggressive right from the beginning of liberalization, and in collusion with the state, it was able to force implement large scale privatization, which also led to retrenchments across the sectors. It was also able to force the state to initiate pro capital labor reforms and overlook large violations of labor law. And it also led to neutrality in labor capital relations. Rather, say, relations were leaned towards capital, and that led to creation of organized and unorganized sectors on a large scale. Do you think that these four labor codes, rather than achieving gradual disappearance of the unorganized or informal sector, it would rather expand it? Do you think gradual appearance of disappearance of the unorganized sector is even possible? Should we even demand for it?
Okay. So what I'll do is I'll indirectly answer your question by referring you to just a broad thinking of the Arjun Sen Gupta Commission on this issue, because we were looking at the labor market from below. As Professor Sophy pointed out, we were interested in looking at the bottom end of the labor market, the unorganized workers. And what we believed was, the fact is that there are large scale inherited inequalities in the labor market between the upper end of it and the organized end of it and the unorganized end of it. But what we argued is that how do you deal with this duality? Okay, so the mainstream neoliberal argument is that you introduce labor market flexibility and undo what organized labor has earned for itself through centuries of struggle. Okay, so that's one way of looking at it. What we said in the commission was that if you want to actually improve the lot of unorganized labor and reduce duality, you do things at the bottom of the pyramid. What do you do? First of all, you introduce what we call social wages. And social wages was not just minimum wages, but minimum conditions of work, basic amenities like housing, education, health, and so on for the working class. And so all this package of measures, which is what? So you introduce this for the working class, combine it with the introduction of universal social security, at least a minimum package of social security measures for all workers. And when we said all workers, we meant not only the wage workers, but also the self-employed workers. The argument was that if you do this, then you do what we call the leveling up of wage workers. So you do a leveling up. If you do a leveling up, the incentive for the organized sector to resort to the lower end of the labor market through outsourcing, through contract labor, and so on and so forth will go down. So if you want to reduce duality, what you do is improve the conditions of work and improve the conditions of living at the people at the bottom of the pyramid. This is and combine this, of course, as I said at the beginning of my lecture, with simplification, rationalization, and harmonization of labor laws so that the working class themselves can comprehend those labor laws and can fight for itself. The more complex labor laws are, the more difficult it is for working class to comprehend what is in its interest and to fight for it. I mean, a very case in point is minimum wages. The large number of categories of minimum wages. So this was in essence the argument that we made, and this is, I think, the what the labor courts have done it. They have approached it from the other end of the stick and from the wrong end of the stick. So they have taken the basically liberalization at the of the organized sector laws as a starting point, and they believe by doing this they can correct distortions in the labor market, they can improve the quality, the quantity of employment, and so on. Our basic argument has been that no, you cannot do this. You can do this by addressing the bottom 70 to 80%, the needs of the bottom 70 to 80% at the bottom of the pyramid. If you do this, combined with some changes that you make also for the organized section of the working class and labor regulations, you will be able to create a much better precondition for equitable growth, inclusive growth, and sustained growth in the economy. I would encourage you to read, you mentioned the 2007 report, Professor Sophy, the introductory chapter in our final report. Yeah, the 2009 report.
Yeah, just to add to
Yes, ma'am. Yes.
so just to add to the conversation again, so after Arjun Gupta's report, when the Unorganized Sector Social Security Act came in, the question was whether Social Security for the unorganized sector is provided within the Act as a matter of entitlement. But when you look at the enactment, we see that it's only compilation of certain BPL schemes, which is already available for the BPL families then. And when you again respond to the question historically, this bifurcation between organized sector and unorganized sector, it's also been facilitated by the judicial discourse. So we see that post 2000, especially post 2000, there have been judgments which sort of took away rights of the workers, especially the contract workers, incrementally. So under the Contract Labor Act, it was felt that automatic absorption is no more right. It's matter of, it's the discretion of the employer. So contract labor would remain as contract labor for the life together. It's no more a right to get absorbed into the organized sector. So in a way, the judicial discourse has also facilitated this wide gulf between the organized labor and unorganized labor. And another important, maybe, if you're interested in looking at how legislations look at legislative amendments facilitated this gulf between contract labor and regular workers. We can also look at retrenchment definition of in the Industrial Dispute Act. So the 1985 amendment, which added 2OBB into the legislation, that sort of facilitated the contract workforce to be excluded from the ambit of the retrenchment provision. So the employer has the power to fire the employee, fire the workman as soon as the contractual term is over. So that sort of categorizes the workman outside from the ambit of Industrial Dispute Act. So in a way, the legislative amendments and judicial discourse has clearly categorized contract workforce out of the industrial relations laws, and this has sort of put them into more informality, precarity, without any legal protection.
May I ask a question?
Yes, Kareem.
Yes. Welcome, respected sir and ma'am.
Regarding,
Please, Kareem, sir. Please, Kareem, sir, go on, please.
yes, regarding the wages of these contract workers and other things. Earlier, there was an act, Equal Remuneration Act, As per the spirit of that act, Supreme Court judgment was there. While a contract worker is working in a factory, he is entitled to the wages which is to be paid the permanent worker. Now, that judgment has gone because the Equal Remuneration Act is subsumed by the new code. There is no Equal Remuneration Act now. It is not only equal wage for men and women, it was equal wage to permanent worker and contract worker in the if agreement. These all are for the formalizing our economy. Our jobs are getting formalized. That is what is happening in the country. Private sector is getting formalized.
Yeah.
Yeah.
I think Tarun wants to comment, and we can.
Yes, sir. Yes, sir. So basically, I have two questions. Uh, One is a little historical one, and one is more forward-looking. So my question is, Professor Srivastava, you and Mr. Kareem both mentioned that how we forsake the Keynesian economic model which we followed of a more welfare state to a more liberalized system. And I think current in the contemporary situation, a lot of economists are coming out in criticisms of the liberalization model. So the how did the model revert back to a liberalized and pre-depression economic model at the first place? So what
Okay.
were the factors leading which led to the Washington strategy rather than a Keynesian and holistic welfare state model of economics?
Okay. So no, you said two questions, right?
Right. Should I ask the second one also?
Well, I mean, I can give you a very quick answer to this one so that we can try to round off as quickly as possible. So,
Yes.
the basic, yes, whenever changes happen, there are obviously also objective conditions which help changes to happen in a certain direction. And the objective conditions which forced a retreat of Keynesianism was the fact that in the 1917, 1980s, we had a long spell, almost an 8-year spell of what is known as stagflation. A stagflation is a condition where slow growth is accompanied by inflation and Keynesian prescriptions do not work. Okay, and that led to the rise of what we call monetarism, people who believe in monetarist policies, people like Milton Friedman and so on and so forth. So that was the economic side of it. But the political economy side, as we've already pointed out, was extremely important. Two things happened. One is that the globally the emerging economies and the what were then known as less developed and least developed economies, they ran out of steam. Because they had been taking debts. The fuel prices fell first in 1973 and then 1979. And the debt meant that the IMF and the World Bank became extremely important. They started imposing conditionalities on the developing world in terms of how they should expand. And the third thing which has happened, we've already mentioned, which is the decimation of the socialist world and the Soviet world and the rise of a unipolar world headed by the Soviet, the US. So that what
US.
happened was that the coalition of interests, this is the Washington consensus is what? The Washington consensus is the consensus between the US Treasury, the IMF, and the World Bank. And this Washington consensus began to rule this way, and the objective conditions which furthered it was the fact that it was able to bring about a more rapid pace of globalization, and the technological changes which Mr. Kareem referred to also helped it rapidly spread. Uh, since about in fact, since the beginning, but since 98, 99, we had first the East Asian crisis, and then we had the 2008 crisis, and then the current crisis, and so on. The counter arguments have been fielded very, very strongly. This has led first to what is known as the modified Washington consensus, and then what is most accepted now globally, the decline of the Washington consensus. So the alternative arguments, the heterodox arguments about the role of the state, about the role of state in the management of the economy, the bottom of the pyramid, and so on, have become far more formidable now than they were in the late 80s and the early 90s. So this is the way economic arguments develop. Economic arguments are shaped by objective reality, and the objective reality of the last three crises has helped to bolster the critique of neoliberalism and the Washington consensus. And in fact, even the World Bank and IMF have shifted their positions on a number of things. You know, they decimated the Indian economy, they decimated public transport in the Indian economy, they decimated the power sector in the Indian economy, and so many other things. Now their own position with respect to all this has changed in the 2010s and the 2010s. So this is how economic discourse develops globally.
Thank you so much, sir. Sir, my next question is along the same lines, which you said that the IMF has changed its global position. And I think even in the United States, there is a consciousness developing within the people about the harms of liberalization. And there are many movements such as the Occupy Wall Street movement. And even in the current 2020 elections, I think inequality and liberalization is one of the main agendas. So, sir, do you think like United States is clearly moving against this liberalization of its past? But do you think in India also, I think this question is to open to all the three of you. Even in India, do you think such a movement is going to arise in the future and the coming times where we are going
Okay, so I'll very
forward
quickly,
towards liberal?
I'll very quickly address it. I'm sure Mr. Kareem and Professor Sophy both would love to come in on this. So globally, what neoliberalism has done is that it has increased inequalities. Most countries in the world have seen a very, very significant increase in inequality, including India. And this has then, it has an inequality overall in wealth and in income, but also informality. Informality and labor market precarity has increased all over the world. What this has done is that this is because inequality precipitates social movements, political unrest, turbulence, not only of one kind, by the way, of many kinds. It can even be in the fame of the response to inequality can be racism. The response to be inequality can be communalism. It can be fascism. It can be working class movements. It can be rainbow movements. So the response to inequality can be in the shape of many different kinds of movements, and there can be many different types of responses. But what has happened is that globally there has been a response to rising inequalities, and many countries have now started addressing issues of inequality and informality. So if you look at emerging economies, Brazil, China, South Africa, they are far ahead of us in addressing issues of inequality and informality. India is one of the few countries, I would say the only major emerging economy, which still does not have a framework either to address inequality or to address informality. And one of the repercussions of that is what you see today. It is the rise of a the political reaction that you see to this in the form of majoritarianism and so on and so forth is partly a response to the fact that conditions on the ground are becoming very difficult for working people in this country.
See, the discontent among people, particularly among the working people, is growing all over the world. But that aspect is dealt by the ruling classes using racism, pseudo nationalism, fascistic policies, and majoritarianism. Like in India, in America, also, United States, also, Trump is advocating such a policy. In Brazil and several European countries, dividing the people and dividing the working class forces. That is what happening all over the world. But once working class or farmers are united, we can compete with them. That is a glaring example is the united struggle of Uttar Pradesh electricity board employees. They were able to stop the privatization of the distribution system of eastern UP electric supply. And other example is the farmer struggle of Punjab. So there is no question of disappointment. There is a vote.
Yeah, so I think there are a lot of studies which has came out, including Thomas Pitty's study about the rising inequality in India between the haves and the have-nots, right? So I think that this reflection of inequality is in multiple layers in India. We see communalization, we see state-sponsored uh, uh, violence and casteist attacks. All of this we see, all of these are reflections of inequality, and also that the state is unwilling to address underlying issue, underlying issue of rising informality and precarity in the society. And I think when we think of a movement or a mobilization from the bottom, it has to be a clearly thought out strategy. I think there are movements, there are alternate movements which are thinking of from multiple corners, where they think of different identity groups coming together. Because as NCOS reports mentions, a majority of workers in the unorganized sectors are from SC/ST minority communities. And since they are in the bottom layer, they are the victims of inequality and inequality, informality, and precarity. And also the government measures of the recent economic preservation to the majority community, etc., hasn't really gone well with the oppressed communities in the country. So definitely, I think the when we think of mobilization, the mobilization has to be political. It has to be ideologically rooted. It cannot be merely on the economic ground, because the economic strategy of the government, uh, uh, the government also comes through um, multiple layers. So yeah.
Thank you so much for your answer.
At this closing instance, I consider it a great privilege to be proposing the vote of thanks on behalf of Legal Services Committee, National Law University, Delhi. We would like to thank Professor Ravi Srivastava for being with us today and setting the tone of the lecture by highlighting the economic and political factors that influence labor reforms. We also wish to record our sincere appreciation to Mr. Kareem for presenting his thoughts on the importance of consultative process in labor law drafting. We also express our gratitude towards Professor Sophy ma'am for moderating the event and sharing our own thoughts on labor reforms and labor codes in our country. A special thanks to my colleague, Preetham Daman, for helping in the execution of this idea. We have been working on this project for 2 months, and it's really satisfying to see the fructification of the first segment of this lecture series. Thank you to all the panelists once again. Thank you to all the members of the audience. We do appreciate the spirit of asking questions, but let's read more, understand more, and question more. Thank you. Thank you so much.
Thank you. Thanks.
Thank you. Thank you.
Thank you. Thank you.
Thank you so much.